Good morning and welcome to Law Talks here on 4CRB. Well, today we're turning to a really important question for parents. What happens to your children if something happens to you? One of the most important parts of a will for parents with young children is appointing a guardian. But many people aren't sure how that works, whether it's legally binding or what happens if family members disagree. So today we're going to walk through some of the most common questions parents ask when it comes to choosing a guardian. And we're joined today by wills and estates lawyer Leigh Steyn from Attwood Marshall Lawyers. Leigh, thanks for joining us this morning.
Thanks for having me again. It's good to be back.
Well, what does it actually mean to appoint a guardian for your children in your will?
So if you have young children or may have them in the future, your will should always appoint a guardian. Appointing a guardian gives someone the legal responsibility to raise your child if you're gone. So making those decisions about education, healthcare, living arrangements and finances.
Okay. And is appointing a guardian in your will legally binding, or is it more of a guide of your wishes?
So this may confuse some of your listeners.
Okay.
So it's legally recognized, but it's not completely binding. It's more about making sure that the children's best interests are protected. So per the Succession Act, a parent can appoint a testamentary guardian in their will, and the position takes effect on your death. With that being said, the court also does have the overriding discretion to appoint or remove a guardian in certain circumstances.
Okay, and what are the most important things parents should consider when choosing a guardian?
Well, they'll be replacing you, so they need to make sure that they've chosen somebody that's going to be able to house their children, clothe their children, educate them children, like I said earlier. So I would just make sure that the person you're appointing as your children's guardian is prepared to take on the role and responsibility. And I always suggest to talk to them and make sure that they hold similar ideas and views as you. That's quite important as well, because you want your children to be raised in the same mannerism
and values. And perhaps if there's cultural beliefs or something like that.
Exactly.
Yeah,
yes.
Okay. Now, many people instinctively think of their own parents. What if you're worried about their health or their age?
This is actually exactly what happens, is that they do choose their own parents or they choose their siblings. And I normally raise a conversation and I just talk to them and I'm like, what does that entail? Are your parents healthy? Like, that's something they need to take into consideration. You can't be having your mum right now, she may be about 60. Your child may be 3, but in 10 years' time, she'll be 70. Is she an old 70? Is she a young 70?
Yeah.
Can she look after a 13-year-old teenager? So those are the things that you've got to take into consideration, when appointing a parent as such.
Yeah. And what happens if both parents pass away at the same time?
Okay, so the executor of your will liaise with the guardian, and the guardian would have to accept their position. If they don't accept for their own reasons, then the court will come in and they'll need to be approached to determine who is fit and proper to be the next guardian. During the period of uncertainty, I'd say someone can volunteer to take the children on, and if they can prove that they are that the children are comfortable with them, then they will possibly be left with that certain person.
Okay, and is that why it's important to name a backup or substitute guardian in your will?
Yes.
And what happens if parents are separated and they each nominate different guardians in their will?
Then it becomes survival of the fittest parent. So it boils down to the last will that's read. But also, once again, the court can be called in to assist. And should a family member or someone close to the children not be satisfied with who the named guardian is, then they can actually seek legal advice and approach the court.
Okay. And if one parent passes away, does the surviving parent automatically become the child's guardian?
They do, unless that parent has formally been removed from their parenting rights. Then the surviving parent, even if they are separated, would always be the guardian, but if the surviving parent's been removed, they won't.
And what if the surviving parent has limited or no parental rights due to, say, family law orders? What happens in that situation?
If you've named someone in your will as the guardian and the surviving parent has lost their parenting rights, then the guardian or your executor can make a request to the court. It always boils down to what the child's needs are and what their best interests are.
Okay, and finally, if parents are unsure who to choose as a guardian, what's the first step they should take?
Think about their children's needs, the circumstances of their nominated guardian, and make sure that the person that they're wanting are capable and available. And sometimes just because a person has said yes to you, they'll do it. That doesn't mean that the parents shouldn't think carefully about it. They should still consider whether they've chosen the best person available.
Yeah, okay. Well, that's all we have time for on Law Talks today, Leigh, and we hope that we've given you some clarity and some great ideas about putting the right documents in place to ensure loved ones are protected. Thanks for joining us today, Leigh.
Thank you. Thanks for having me.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.